Hello friends, myself Mohit and I am going to dictate you Stano Legal Matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
We have given our thoughtful consideration to the matter stop. As already noticed, the petitioner is undergoing life imprisonment in case FIR number 156 dated 17/05/2009 registered at police station district Jalandhar for the offence punishable under section 302 IPC. Stop. He has been convicted in the said case and sentenced to undergo life imprisonment. Stop. Criminal appeal, that is CRAD number 954 DB of 2010 filed by the petitioner is pending in this court. Stop. The provisions of the act provide for the temporary release of prisoners for good conduct on certain conditions as enacted by the legislature of the state of Punjab. Stop. Temporary release on parole is granted on certain conditions as envisaged by the provisions of section 3 of the act. Besides, temporary release on furlough is granted in terms of section 4 of the act. Stop. In terms of section 5A of the act, prisoners are not entitled to temporary release in certain cases like cases where death sentence has been awarded or a prisoner is a hardcore prisoner. Stop. Hardcore prisoner has been defined in section 2A of the act as follows. Stop. Hardcore prisoner mean a person confined in prison under a sentence of imprisonment who has been convicted of an offence of rape with murder under section 376 read with section 302 of the Indian Penal Code 1860, an offence punishable under section 14 of the Protection of Children from Sexual Offences Act 2012. The petitioner does not fall under the said category and therefore is not a hardcore prisoner. Stop. Besides, section 6 of the act provides that notwithstanding anything contained in sections 3 and 4 of the act, no person is entitled to be released under the act if on the report of the district magistrate where consultation with him is necessary, the state government or an officer authorized by it in this behalf is satisfied that his release is likely to endanger the security of the state or the maintenance of public order. Stop. Therefore, release of a prisoner on payroll can be declined in case his release on payroll is likely to endanger the security of the state or the maintenance of public order. Stop. The recommendation made by the district magistrate respondent number 3 for not releasing the petitioner on payroll is merely that the petitioner is undergoing life imprisonment in a case like murder, so there is a probability that he may commit a crime on release on payroll. Stop. The likelihood of committing a crime while on payroll would not be a sufficient ground to decline temporary release on payroll, as mere likelihood of committing crime is not to be taken as apprehension of a threat to the security of the state or the maintenance of public order. Stop. As already noticed, payroll can be declined in case the competent authority is satisfied that his release is likely to endanger the security of the state and maintenance of public order. Stop. No such eventuality has been mentioned in the present case. Stop. This court, in case of Varun versus Gullu versus State of Haryana and others, no doubt payroll on furlough is a concession granted to a prisoner, but grant of such concession is regulated by a statute, and on fulfillment of conditions prescribed therein, a prisoner is entitled to payroll. Stop. The concession of releasing a prisoner on payroll or furlough is circumscribed by a statute. Therefore, the release of a prisoner is in exercise of the right created under that statute. Stop. Therefore, the authorities under the Act cannot act arbitrarily or without due application of mind. Stop.